like to briefly just walk you through the steps involved in filling a release of information request. I'm going to go over filling a mail-in request, walk-in request, what you should do if you receive a subpoena, and it's your responsibility to honor that subpoena. I'm not going to cover every situation that could possibly come up, but I'd like to at least walk you through the process so you'll understand what the release of information individual does on a daily basis. First of all, where do we get requests for release of information? Requests come from a number of sources. They can come from other healthcare facilities, other healthcare providers, insurance companies, lawyers, maybe the Social Security Administration. A lot of times we'll get requests for copies of records for disability determination, the Department of Public Safety. I've dealt with those a lot, especially when I worked in alcohol and drug rehab, that one of the provisions for an individual who had had a conviction for DUI or driving under the influence may have had to go through some type of treatment in order to get the license back, and so we would mail copies, of course, with the patient's consent or authorization. We get subpoenas and court orders for medical records. Sometimes it's the patient or the patient's family that requests copies of records. And then I put et cetera in because there's a lot of other types of requests that we may get. And most of the requests that we get for release of information come in the mail. But sometimes we get walk-in requests. I mean, people just show up at the department, say, I have an authorization for release of information, and I want copies of the record. Sometimes it will be the patient coming in requesting copies of the record. In order to release information, we have to have a valid authorization from the patient or a subpoena, a court order. Now, when I say we have to, this is under most circumstances. We've gone over in previous discussions times when we do release information without patient consent. And we had a whole chapter on that in cases of child abuse or there's gunshot wounds. We have to release information to the state or the health department as far as statistics for vital statistics, birth certificates, death certificates, those types of things. But normally the rule is that we only release information if we have valid authorization from the patient or we have a subpoena or court order. Now, HIPAA describes a valid authorization as one that contains the following items. The authorization, and I have an example of one. I've also provided you one in your handouts, that the authorization should have the name and some identifying information on the patient so that we can make sure that we have the appropriate patient's records to release. Also, the name of the party who is to release the information, as well as the name of the party to whom the information is being released. We need a purpose for the release, such as continuity of care, continued health care, disability determination, insurance payment, those types of things. We want that recorded as far as the reason or the purpose for the release. A description of the information that is to be released, meaning a listing usually of those reports that we are to release off the record. Expiration date or the event that will take place. For example, an expiration date is pretty straight to the point, but sometimes we have an authorization filled out and there will be an event at the conclusion of treatment or an event such as that. Also, we need a statement that the authorization may be revoked, and also a brief description on how a patient would go about revoking an authorization. Does it have to be in writing? If it does, to whom does it need to be addressed? Those types of things. But we need a statement that this authorization can be revoked, meaning just because you signed it doesn't mean that it's in that you have to live with this forever, that it can be revoked. Also, a statement on redisclosure. And what we mean by that is that the patient needs to be aware that once we mail the records or release the records, we have no control over the person who is receiving the records or the party that's receiving the records. And so a brief statement stating that, there is a chance or a risk in redisclosure by the receiving party. Also, it needs to be signed. This authorization needs to be signed by the patient or the patient's representative. A representative could be a parent of a minor. A representative could be someone who has power of attorney. So we need either the patient or that patient's legal representative to sign the authorization and date it. And if it's the representative, we need to record the relationship to the patient. There's an example of a valid release of information authorization. I'm including this in your handouts, and I have included this particular authorization in the HIPAA section when we have the discussion on HIPAA. But this one is actually filled out, and it's filled out appropriately. And in your handouts, I have given you the same authorization. Let me open that up. This is the authorization, but I have put some notes on it, and so you can click on the comment icons and the notes will pop up. And for example, we go through here and indicate all of those sections that are included on this authorization that make this authorization actually valid. So the first thing we have, I hereby authorize General Hospital. Well, General Hospital is the party releasing the information. We need that on the release form. Also, we have the patient's name and identifying information on the patient. It's important to have at least one more item that would uniquely identify that patient. The example I gave here is Jane Doe. Well, our hospital may have had 15 or 20 Jane Does, so we need something very specific to make sure that we have information, or we're pulling the records of the appropriate patient. The next thing is the party receiving the information and the purpose of the release. We have an additional section here, dates of treatment. The patient may have been coming to the hospital or to our health care facility for years and years and years. And so we want to make sure that we're only releasing the appropriate information, so we will have dates of treatment recorded. And also, this is the description of information to be released. To make it easier, we have put it in a checklist form, but also included other, because there's always something else that we could have included, but at least we won't have to write these same items over and over. The next section of the authorization is indicates the date of expiration and instructions on how to revoke the authorization. And if you'll notice in this particular example, I understand that if I revoke this authorization, I must do so in writing. I understand that revocation will not apply to information that has already been released. In other words, the patient can't come back later and say, well, yes, I signed the release, but I revoked it, and I want them to take back all of the information they sent legitimately before I revoke the authorization. Here is the statement for redisclosure. I understand that any disclosure of information carries with it the potential for unauthorized redisclosure of this information by the recipient. And then there's the patient's signature and also the date that it was signed. Now, I put a note on here to be sure the date signed is after the treatment dates. And what I mean by that, when you are doing release of information, you make sure that if the authorization says, I want for you to release information covering the periods of health care from 10/19 to 10/23, Or maybe this section is not on the authorization. That was the one I said that was added, and you'll find that in a lot of authorizations. But if, for example, 1019 to 1023, that this patient is saying, I want you to release my H&P, discharge summary, operative report, and PACA report, and then that patient actually signed this authorization on the 6th of November for information on his, or now that would be her, treatment from October 19th through October 23rd. This lets us know that the patient is doing this as informed consent, meaning that the patient understands this is the information you're going to release from my record. It's from these dates. And if the patient had, if the requesting party says, send us the information from a treatment episode that happened after the patient had actually signed the release form, we wouldn't do that. We make sure, because if that was the case, the patient wouldn't even know when they signed the release form that they were going to be in the hospital again. They were going to receive more treatment. And so that would not be informed consent, basically, or an informed authorization. And so we always make sure that the date the authorization was given was after the date of the information that we are releasing. Now, another thing, and I want to minimize this for a minute. I'm going to come back to it, but I also want to go over mail requests. With mail request, we check the authorization for validity, going over those items that I just covered. Compare the signature with the known signature of the patient. And what I mean by that is we need to look at the authorization and then maybe pull the medical record, and that patient is going to have signed that record somewhere. And usually, the consent for admission, any consents for surgery, there's a lot of paperwork in there that the patient has actually signed. So we'll compare those signatures. If those signatures don't match, then we don't fill the request. And we do have to take into account that sometimes when people are in the hospital, they're not feeling well, their signatures may be a little bit different, but there's some patterns that you can see with signatures. And so if we look at it and if we can determine that it's the same signature, then we'll assume that the patient signed both. But we always look at that. First thing we do is compare the signature on the authorization with the known signature of the patient. Now, if the authorization is invalid or the signatures don't match, then we don't fill the request for the record. And what we'll do is we don't just throw that aside. We will contact the requester, usually in the form of a form letter, because we have to send these out so much that, we will have certain things filled out on the form already, and then we can just check the appropriate box. For example, this authorization was not signed, therefore it's invalid, and we'll return the authorization with that letter explaining why we're not going to honor that request for a record. Now, if it's valid, if we check everything, we check the signature and then we check the authorization for validity, then we copy only the requested information. We don't copy the whole chart. That concept with HIPAA of minimum necessary. So we copy the information. We make a copy of the authorization to accompany those copies. What we'll do is we'll keep the original. And even if we receive a copy of an authorization in the mail, that's okay. As long as it's readable, then we can take that copy just as we can take the original of the authorization. So we make a copy of the authorization to accompany the record. So once we've made the copy, we'll usually put a copy of the authorization on top of the records. And then we document on the authorization that we're keeping what information was mailed, and then we sign it and date it. And when I say we, it's the individual who's actually doing this process. We file the authorization in the chart. Usually there's a miscellaneous or a correspondence section in the medical record, and we file that authorization in the chart. And if we have a computerized release of information system, we record the information that we sent into the system. And then that way the computer system, that release of information system, will keep up with all the requests of records that were mailed. And so do you remember in HIPAA talking about that accounting of disclosures, meaning the patient can come and ask at any time for us to give an accounting of the disclosures or the requests that we have answered. Any information that we have mailed out or sent out, or just in general, anytime we have released information off the patient's record, we should be able to account for that and give that patient a listing, and it is called accounting of disclosures. Now, we've done that in the past. We've basically always done that by documenting on the authorization the information that was mailed, and we sign it and date it. And then that way, even though it's not as simple as going to a computer, opening up the release of information program, and printing out a sheet that will tell us all the information that's been released from a particular patient's record, what we would do is pull that patient's record and go to that correspondence section, look at all the authorizations and all the documentation, and we should be able to accurately tell that patient, we released this to this person or this party on this date. We released the discharge summary to your lawyer on this date. And so we always had an accounting of the disclosures, but we weren't required to keep that. Now we are required by HIPAA to do that. And so it's the same thing. It's just one is a lot more time efficient than the other. And so, and a lot of times we do both now. We will make a copy of that authorization, put it in the patient's medical record, and on it we document what we sent, but we also input that data into the release of information system. Then we mail the information to the requester. Now I want to show you briefly. Let's go back to that authorization. And down here at the bottom, if I was filling this request, once I had completed it, I would document on the bottom of the authorization, H&P, discharge summary, op report, and path report, mailed, say 11/30/06, and then I would sign it and put the date that I made that notation, and then that way this is filed on the patient's record. We can pull it out. So yes, we received that request, and we filled this request on this date, and this is exactly what was mailed out. So that's what I'm talking about, documenting on that authorization what was done. But also we can do it, again, in a computer system, and I will show you an example of an accounting of disclosure that is computer generated. We have gone through these steps.
And now let's look at what we would do with a walk-in request. It's basically the same, but there's a few more steps that we go through because when we're mailing something, we are assured that the person that we mail it to is the person that will receive it, or the party that we mail it to is actually the party that will receive it. But with walk-in requests, we have to be very careful, and we have walk-ins, even though now HIPAA says we've got 30 days to fill a request for copies of a patient's record. But normally, if we don't take that long,
But if the patient does request the record, we can take up to 30 days, but if we get a walk-in request, a lot of times we'll answer that. It just depends on the facility. Some may have a policy that we do not immediately fill those requests and that they should leave the authorization and they can come back and pick up the records at a later date. But sometimes we do have to fill those immediately. And so what the Release of Information Coordinator will do, first thing, is check the authorization again for validity. If invalid, don't fill the request. The next step, because we're not guaranteed, like we are with the mail, that that it is the law that no one is supposed to open another person's mail. In this instance, we verify the identity of the requester and make a copy of the identification, even if the requester is the patient. And so what we'll do, if somebody walks up to the front desk and says, I'd like copies of my medical record, or I'd like copies of the medical record of this patient, and here I have a signed authorization by the patient that gives me permission to have these records, then we will immediately say, I need to see your identification, please, a picture ID. And what we'll do is verify the identity, that the person showing you that ID is indeed the one whose name is filled out on the authorization. We will also compare signatures again, do that same thing, comparing the patient's signature on that authorization and with one in the medical record. The reason that we do this, I've had instances where maybe a spouse, I remember this one specifically, a spouse came in the department and wanted a copy of his wife's medical records. He said that she had sent him, and I believe that she had to go to the doctor, and so she just sent him to the hospital and said, I need copies of the records so I can take them to this new doctor that I'm seeing. And I didn't doubt that, but he showed up without an authorization, and his wife was not with him. And so we turned down the request and said, no, here's a blank authorization. We'll need your wife to fill this out. And he had already said that his wife was at home sick. And so he disappeared, and about 3 minutes later came back with that authorization filled out and signed. And so we compared the signatures. The signatures did not match. And so, again, we denied the request. What he had done is just gone out in the lobby and filled it out and brought it back and represented it as his wife's signature. And he said, oh, well, I meant she really was with me, but she was just in the car. She didn't feel like coming in. And so that's what I'm talking about. We compare signatures. We then make a copy of the authorization. If it's valid, we make copies of the requested information. And again, document on the authorization the information that we released. We sign and date it. We file the authorization and a copy of the identification. And we put that with the medical record. And that shows that we did verify that person's identity. And so if it's a driver's license, we just take it, go make a photocopy, and then usually staple it to the authorization before we file it into the medical record. And if applicable, we record the details of the release in the computerized release of information system. Of course, we put the records in an envelope and give them to the person if it's, again, if everything's checked out and this is a valid request for release of information. Now, quickly, before I go over subpoenas and court orders, I'd like to show you what I'm talking about that accounting of disclosures. As I said, all it is a list of exactly what was released from the patient's record and when and to whom. And so if we use a computerized release of information system, we will put the request in the system as they come in, and then we will go back into the system and enter the exact information that we sent out as soon as we have filled the request. And then that way we can also check to see if we get a call, and we get these all the time, maybe from an insurance company. Did you receive our request for release of information on patient Jane Doe? We mailed it, last week. And so we usually have to keep it, maybe just the requests that weren't answered in a particular folder, and we can go through those, or we pull the patient's record, and if we've answered that request, we go to that miscellaneous section. We look and see if it's documented that we have answered, we have filled that request. And so, if we have the computerized release of information system, we put that information in the computer. And then, with basically the touch of a button, we can print out all of the disclosures from that patient's record. So here's an example of one that was generated on a computerized system. And maybe the patient, maybe Benjamin Johnson came to the department and said, I would like to know the information that you've released from my medical record. And so we can go to the system and print Mr. Johnson an accounting of disclosure as required by HIPAA. And notice we can tell what date the information was disclosed, who sent it. We can tell who it was sent to or to whom it was sent, the address, why we sent it, and also what we sent. So in this case, path, op, discharge summary, and H&P was sent out. And so that is an accounting of disclosure. That's an example when you hear that term, especially when we're talking about HIPAA. It's just an accounting of what information has been released from a particular patient's record. Okay, let me get back to the presentation. Almost through. The last incident or situation that I want to cover is subpoenas and court orders. We've gone through this in the textbook, and when I did a presentation on Alabama law specifically, I'll touch on this a little more and give you some examples, really show you a sample of a subpoena, but this is just the general procedure. And what you should do is, just as we check for the validity of an authorization, we check for the validity of a subpoena. And again, in the Alabama law section, I will cover what constitutes a valid subpoena. It has to have the docket number on it. It has to have the seal of the clerk of the court. Different things like that. And we look and make sure that all the information that should be on that subpoena is on there. And so we check for validity. If it's not valid or some of the information or items are missing off of the subpoena, there will be a contact number for the attorney who caused that subpoena to be issued. And so if any information is missing, we will contact that attorney or that attorney's office and say, we're missing this information. We need a valid subpoena in order to honor this subpoena. Now, if it is valid, it all checks out, everything's on there. First thing we do, we pull the record and we number the pages back and front. That's something that we don't normally do on a regular release of information request, but on a subpoena we do. And we'll number those pages. We'll copy the record and copy the subpoena also. And to go back, the reason that we number the pages, if you remember us talking about, or me talking about business records and getting subpoenas for business records, and the medical record is considered a business record, that we then have to certify that record and say this is a complete and true copy of the record. One way to show that, especially on Xerox copies, if we're copying the record, if someone can look at those copies and see that the page numbers are on there and that there is a copy of every page in the record, that gives you proof, because if you just have copies of the record sent and no page numbers, there's no way to identify if a page got left out or something like that, because they normally don't have the original unless they just say, no, you have to show up in court with the original. Normally, we're mailing certified copies of the record, and that's why we number the pages back and front. So then we make a copy of the record and the subpoena. We complete that certification. And again, I'll give you an example when we go over the Alabama law. There's a particular certification. It's not a particular form. It's the wording has to be exact. So sometimes you'll see it. Of course, we usually just have it on a piece of paper printed over and over and over, and it has blanks where we fill in the patient's name, and we certify that these are business records and they were kept in the normal course of business. And so we complete that certification on the record, and then we seal the records in an envelope. We seal them in a way that if it's tampered with, it's obvious. We make sure that everything's stuck down, but then we usually go that extra step and put all the tape around the seals and everything so that someone can't get into that envelope. And then we attach that certification to the outside of the sealed envelope. Now we record the subpoena in what's called a subpoena log. It can be done manually or computerized. And if we have a computerized release of information system, one component of it will just be a subpoena log. But we keep a separate log of all subpoenas that we receive, and then what the outcome was. Did we honor that subpoena, or was that an invalid subpoena? And so we record the subpoena in the subpoena log, again, whether it's manually or computerized. And we also record the information that was released on the subpoena. If applicable, we put it in the computerized release of information system. We're treating the subpoena just like we treated the authorization, just marking down on there. And a lot of subpoenas will say the entire medical record, and so we would document on the subpoena entire medical record, mail to, and what we do, we mail it to the courthouse. Or sometimes, if we don't have time to mail it, we actually have to deliver it and make sure it gets there in time. So we mail or deliver it, we deliver those records to the court. That subpoena would then be filed in the same miscellaneous section, and that we file the authorization in when we're talking about just a regular release instead of one via a subpoena or a court order. So that concludes this presentation. Just a brief example of the steps that you would go through if you actually do release of information in the Health Information Department.